All right, good afternoon, everyone. Katie Busbee and I are glad to be here with you today to talk about legislative updates. Thank you for enrolling as usual. And I see we have a lot of attendees today, so let's go ahead and get started. We have a lot to cover. We got offices everywhere. Don't forget to submit your questions in the Q&A or chat, and we'll answer them as we're able. We'll give you the recording and the slides. Y'all know all that. Always communicate with Brittany if you're having trouble getting your credentialing. Next slide. All right, so this is what we're discussing today, and y'all, we have a lot to cover today. We could have covered more. But we're going to start with the Department of Labor, the two crucial issues with the DOL or the FLSA salary threshold, which y'all, this is not news to y'all, and then the employee independent contractor regulation that came out. We are going to cover FTC and some federal proposed legislation about non-competes. The National Labor Relations Board been very active. Katie's going to talk about handbook severance agreements and the joint employer test. I will talk about the expanded OSHA reporting and the EEOC proposed harassment guidance, which is expected to be issued this year. And then we'll cover, some things to remember about election year and some other trends if we have time. So with that, I think we'll just slide right in. But first, before we do, that's right, I dropped the slide in and then forgot I dropped it in. Just to put some things on your radars, and Katie and I talked about that we'll probably reconvene and discuss some of these later this year. Don't forget that in 2024, you're looking at accommodations under the Pregnancy Workers Fairness Act, the ADA, and religious accommodations, all under the same standard. And in fact, the PWFA is a little more heightened standard for employers. And so we covered that last year, and I think we're going to hit that again this year. That's something that we're getting a lot of questions about. Federal contractor, you're going to end up, if you're a federal contractor, having to provide more information to the OFCCP in 2024. Presumably, if you're audited or if you're one of the ones selected for audit this year, you should have gotten notified by email. And then always keep your eye out for pay equity, transparency, legislative action. Pay equity is already a legal requirement. There's already several laws that address it. But this particular area has additional rules about what you can and can't ask. And so that continues to be brought up and at some point maybe get passed. Look at our blogs. We'll alert you to anything that's getting passed. All right, next slide.
Okay, I'm going to jump in here and talk about the proposed rule that the FLSA has put out for non-exempt, exempt workers. So this was announced early last year, I think, and I think a lot of us expected to see a final rule in 2023, but they have kind of kept pushing a final rule. And so they came out in December and said that we can expect a final rule in April, so this spring. And basically the proposed rule raises the salary threshold, at which point an employee moves from being non-exempt to an exempt, from $684 a week to $1,059 a week. So this is quite a jump. It's more than a 50% increase. And then it also proposes moving that salary level for highly compensated employees. There's a carve out that makes highly compensated employees exempt. So that is raised from $107,000 to around $143,000 per year. So I know probably many of you are aware of this. And so just know that we are expected to get a final rule this spring. And of course, that final rule could look different than these proposed salary thresholds. It could have gone up because at this point they announced this so long ago. So we'll kind of have to see where that lands. Next slide. They also included in the proposed rule this concept that these salary thresholds would automatically adjust every 3 years. And so that's new. Normally we kind of wait on the Department of Labor to issue a proposed rule, and then it has to go through the notice and comment period and all of that. And so this idea that every 3 years it would be adjusted based on current wage data is something very new. And so we'll see if that makes it into the final rule. I will say that employers will have 60 days to comply. So once that final rule is issued, you've got 60 days to get ready for that and comply with the new rule. So this is just kind of a chart showing the history. Like I said, usually we have to wait until the agency issues a proposed rule. And a lot of times, you know, these are challenged in court. That's what happened in 2016. There was a really big jump proposed. I remember when that came out. And a court ended up blocking that. That never went into effect. And so those salary thresholds were raised in 2019. And so the new rule was announced in 2023. So you can kind of just see the history. I think the jump that we're looking at right now is quite large as well. And so just gives you some perspective on how that's developed over the last 20 years. Okay, next slide. So the Department of Labor estimates that this is going to affect about 3.4 million workers. So this is a lot of people. And then the highly compensated exemption will affect about 250,000 employees. So at this point, you really just need to be taking a look at your workers, taking a look at how much they're making, who is this going to affect? And be thinking about, okay, what kind of policies do we need to put in place with these particular workers that are going to be moving from exempt to non-exempt, making sure that we're capturing their hours. So if they're working over 40 hours in a work week, they're getting that overtime pay that they're entitled to. I could also see some employers maybe even looking at the duties requirements. You know, to be exempt under the FLSA, you have to meet those salary requirements and the duty test. And so, you know, that's something to consider as well if you're trying to account for that overtime pay, looking at those duties requirements as well. Okay, next slide. All right, I'm going to turn it back over to Chris for this.
All right, so the Department of Labor's independent contractor rule was just issued, and it goes into effect in March 11. And so, you know, those of us who've been in HR world for a long time, and even those of us who haven't, every time you have a change in administration, there is a change in the independent contractor test. And that typically has been something that we all felt a little blasé about. But with the gig economy and the way that working relationships have changed, you know, particularly in the last years, this has become more of an issue. And so I think, you know, now you see more findings that are problematic for employers, and we're seeing a lot more employers, therefore, have questions about this and want to look into this further. Katie and I were just talking about it. We think we probably need to have just an independent contractor analysis webinar. And so she and I will get together and work on that. But today I'm just going to talk to you about it briefly. So we're going back to the totality of circumstances test, which was from 2021, but it is modified. So it's not exactly the same test. And this replaces the economics reality test. The Department of Labor's guidance is extensive. It uses 6 factors that it considers, and then it gives definition and criteria under each factor to consider. And then also says, you know, a general catch-all, additional factors may be relevant to the economic dependence of the employee. So that's an important term to carry with you about what matters for the Department of Labor in regards to independent contractor status. And that is defined in the rule as an employee who is dependent on the employer for work. Now, I'll note that just because an employee is dependent on the employer to work, or several different employers, the department has decided, even with several different employers, it may not mean that they're not employees. So in other words, employees can be employed by different employers, which we know, right? That's always been the case. But, you know, the Department of Labor takes great cause or great care to spell that out. And I think that's probably because of the gig economy. The other thing that the department did was say that none of the factors actually have a predetermined weight, and they're all considered in view of the economic reality of the whole activity. That's not that big of a departure from before, but in other words, this makes it a very nebulous test, which I would submit to you, independent contractor classification always was. Because there's no single test exists, and if you're being audited by the Department of Labor or the IRS, or you've had a complaint filed against you by the NLRB, or in any litigation with any of these entities, each one have different rules. And then courts have their own rules, interpretations of the requirements. Next slide. So here's the Department of Labor 6 factors. Opportunity for profit or loss depending on managerial skill. So, can the employee, can the worker profit from whatever deal they've struck with the employer? So that's the thing you think about. And I don't mean about salary, but like whatever deal is struck and then the worker has an opportunity to earn more, to save, to make changes in their expenses that they're going to spend in performing the work to earn more. And it has to also depend on their skill level, their managerial skill. The amount of investment made by the worker in comparison to investments made by the potential employer. There's a lot of discussion about this, and it's interesting. The rule actually proposes that there's a comparison pro rata of how much the how much the employer is spending towards the work that's being performed by the worker and how much the worker is spending. So there, again, no hard and fast rule here. But the more money that the worker is spending on investments to perform the work, the more likely the person is an independent contractor. The permanency of the relationship. This is very important. This is very important and always has been important. If this is a sustained relationship and the contract that you have with your independent contractor is renews automatically, that is already a strike against this misclassification analysis. If it is for a definite period for a specific project, that's more likely going to be determined to be an independent contractor status. So this is important. The nature and degree of the potential employer's control. This is interesting. Control has taken less of a seat in the Department of Labor's guidance in this situation, and is given less significance than it has in the past. And then it's also explained in a more detailed fashion, other than the traditional way we used to define control, which is obviously scheduling a worker's work, supervising their work, requiring them to be at work a certain time, that sort of thing. So there's more nuanced factors that are considered. They added back in the extent to which the work performed is an integral part of the potential employer's business. And look, that makes sense, both from the standpoint of even joint employer analysis, as well as independent contractor. Typically, an independent contractor is someone who is coming in and providing a service to the employer that the employer is not able to provide themselves. And there's some very cut and dry standards there examples that you could apply. Somebody coming in to fix the lights, the contractor who comes in and, does certain aspects of administrative functions that the employer doesn't need to carry out its business. So, but this is a factor that's analyzed, and I think in a lot of ways it's tougher when it's an independent contractor because many companies bring in outside expertise in certain areas like engineering and such that they need to be able to run their business. So, and then finally, are they using specialized skills indicative of business-like initiative? That is literally what it says, whatever that means. I mean, you can see where that's a lot of room for subjective analysis depending on who's the adjudicator of whether or not this was misclassified relationships. But specialized skills is what it sounds like, and is the person bringing the specialized skills with them to the company. Is this something that the worker shows up and has marketed this specialized skill and this unique ability to do something, as opposed to the employer is training this worker and teaching them how to do it, and variations of those, various levels of those. Next slide. So just some general observations. I mentioned this, the DOL focuses less on exercise of control and opportunity for profit and loss as the core factors of economic realities analysis, right? So this is an economic reality analysis. Is the employee dependent on the employer, or is the worker dependent upon the employer for income? Not that they don't consider it, but they're considering it less. And if you've been following this, in more recent years, control was always the first factor that everybody ever talked about. So this is saying it's still important. It's just not going to be given the significance that maybe historically it has been. The Department of Labor specifically says that just because a worker earns income from more than one employer does not mean that this is going to be an independent contractor. Just because a worker works for multiple companies does not mean that this is going to be independent contractor status. If an employer is controlling the worker beyond what is required in the industry to comply with applicable legal standards, and you can think about OSHA, other federal and state standards that this industry is subject to. If the company is getting more involved in compliance beyond what the law requires, and or starts requiring the worker to comply with the company's own internal compliance procedures, that's going to be a factor that's considered, in the context of this must be an employment relationship. So any compliance requirements beyond the law is going to be seen as a factor that might support employee status. Investments that are capital and entrepreneurial in nature. I talked a little bit about that worker investment is something that they're looking at, the Department of Labor, when they analyze this. And they distinguish between those that are imposed by a potential employer. So someone who says you've got to come with these tools, you've got to be able to have this, that, and the other. That is not the type of investment that they're looking for to determine whether or not this is an independent contractor. The worker has invested in capital in their business and the ability to do their jobs, and it's entrepreneurial, i.e. it's the worker who has prompted this, created this industry, this business in the industry, and is making efforts to market it and market the abilities. Those are the sorts of things that they're analyzing. Before the webinar, somebody asked about retained and reserved control. So this is a situation where the company has the right to control certain factors but doesn't exercise it. In the past, sometimes that was used as an analysis either for or against a finding of independent contractor classification. The Department of Labor specifically says just because a company does not exercise control over an area where they're permitted to exercise control over, the fact that they can control it will still be considered. Next slide. So the IRS, this is the test that I like to send employers when they are analyzing whether this is a misclassification issue. And it's the 20 factors test. And I dug around and found one online so I could drop a link in. On the second page of the document that's linked there goes through the 20 factors. I cannot tell you how many times I have employers calling me, talking to me about an independent contractor relationship that they either have or they're wanting to create. And it's clearly, to me, not an independent contractor relationship. And so this is a tool that I often use for it to be analyzed. And I also use it to analyze when we've got some factors for, some factors against. The thing that I would say that I would want you to take away from today is there's no one test, there's no one rule. Even the 6 factors that we went through with the Department of Labor, even if you follow those and all the sub-factors very perfectly, it's always a conglomeration of everything all considered together, regardless of what industry you're in. And so it's important to analyze it as thoroughly as you can. And the 20 factors test I like because it's a very thorough test. It's the best tool that I know that we have. And if we've got more things in the independent contractor bucket or substantially more, then we know we're more likely to be able to prevail. Current IRS test focuses on 11 factors, and those center around behavioral control, financial control, and relationship of the parties. Next slide. So I dropped in the NLRB test too, because I wanted to give you all an idea of how similar they are while also showing their differences. And again, here we're talking about control over the details of the work. So that's going to be how the work is done, the time you do it, showing up on time. Is it done with supervision or without? Are they engaged in a distinct occupation or business? This means the worker has their own business and this is the type of work that they provide. How much skill? We saw that with the Department of Labor. Whether the employer supplies the tools and the place of the work, the length of time that the worker is employed, method of payment, whether by the hour job. I continue to see method of payment and what are purported to be independent contractor deals as by the hour, by the job. So, there's ways to do that. Certainly, Katie and I, work on that in these agreements. There's ways to do it, but it's just not as simple as a, quick one-off fix. It's a specific fact analysis, to be honest with you, in the situation and what the employer wants to do. We always want to find a way to do what you want to do, but we want to do it wisely so that you're not having to come back and hire us to defend you before any of these agencies. And then there's the other criteria. Integral work. Is it integral to the regular business of the employer? So next slide. As you can see, all three tests are related and similar. And we don't even get into the courts. So why do we care? So what happens if you misclassify someone as an independent contractor and they're actually an employee? You now are, as the employer, liable to pay federal, state, and FICA taxes. You are liable for the economic value of the employee benefits that were not provided to the contractor from the date you began working with the contractor. Workers' compensation, unemployment compensation, things you didn't intend to have to pay for. And this can be retroactive once it's determined that the relationship is an employee status. It's going to be retroactive. So it could cover things that have happened in the past that the worker covered. Hourly wages, bonus, and overtime. All of a sudden we're not tracking hours of our independent contractors, but if any agency decides, no, this is actually an employee, then all they have to do is provide evidence of their hours worked. And if they're considered non-exempt, you can see how this goes. I will tell you that a lot of times this does come up when the worker finds that they're missing out on FICA or a benefit, or they didn't necessarily entirely agree with it, and they wanted the work when they got it, so they weren't necessarily vocal about it. And none of these agencies are going to say, well, it was an arm's length negotiation, worker, and too bad, so sad. These agencies will analyze it without regard to the worker's involvement. Civil penalties, and then of course lawsuits and attorney's fees. So next slide. What we recommend is you actually audit your independent contractor relationships. As you know, I wrote down here that many independent contractor relationships were already misclassified even under the more employer-friendly test. Note that even if you have an independent contractor agreement, that's what we do recommend, that you enter into these with your independent contractors, that the agencies and the courts can ignore them. They look past those to analyze the things we've talked about to determine whether or not they think this is actually, misclassification. Preferably, you're working with an entity rather than an individual, whether it's just an individual that's incorporated or of some sort of entity rather than the individual. Don't have it open-ended. Don't restrict the work or control the terms and conditions of providing the services to other providers. Some independent contractor agreements do have non-competition provisions in them. It doesn't necessarily void them, but we have to be careful how we draft those. And then an indemnification provision, if you can get the independent contractor to sign it, which says that the worker will indemnify and hold the employer harmless for any determinations by any agencies or courts that the worker is actually considered an employee. Another thing is you can require the worker to provide proof that they pay their taxes annually. And that'll help so that you're not, at least with the IRS. So those are some general things. This is a very specific and kind of thorough analysis. This is where we think you get your counsel involved. Next slide.
Okay.
Non-competes.
Yeah, I'm gonna jump in here. Next slide. So I know we had a webinar on non-competes a few months ago, but we really couldn't do this without mentioning, just because it's such a big issue right now. This proposed rule was released by the FTC about a year ago this time, and it effectively would ban non-competes, that employers cannot enter into a non-compete with an employee. It would also have this retroactive effect that employers are required to go back and notify all or any individual they have a non-compete with and let them know that their non-compete is no longer enforceable. And so quite a burden. It also caught a lot of headlines when it came out, but it is a proposed rule at this time. Next slide. And so the rule kind of sets forth this this test for determining what is a non-compete, because it captures more than maybe what we would traditionally think of a non-compete. And so it says that the term non-compete includes a contractual term that is a de facto non-compete clause because it has the effect of prohibiting the worker from seeking or accepting employment with the person or operating a business after the conclusion of the worker's employment with the employer. And so if you have an NDA or a confidentiality provision, or if you have a non-solicitation that is drafted so broadly that it would effectively prohibit that person from working after they separate from you, then that functions as a de facto non-compete. And so this rule would ban that. And so the proposed rule gives a couple of examples. And so I've included them here. And one of them, you know, they're kind of interesting. So one is what I just said. If you have an NDA that is very broad and could function as a de facto non-compete, then that is banned. And then it also talks about if you have an agreement where you are required to, the employee is required to pay you back for training costs after they separate from employment. And so that effectively makes them feel like they can't separate from employment because they would have to pay you back for these training costs, that in effect would function as a de facto non-compete. And so that's one of the examples they use in the proposed rule. Okay, next slide. And so the proposed rule received just under 30,000 comments. So a lot of comments. And so I'm figuring that's why we've taken so long to get a final rule. And so again, the agency came out in December and said that we should expect a final rule in April 2024. And I will say that, you know, several groups have already come out and said that they will challenge this rule in court, basically no matter what it looks like when it comes out. I know the U.S. Chamber of Commerce intends to challenge it. And so we do expect that this rule will make its way through the court systems and that a court will have the final say, probably maybe even the Supreme Court. So we'll see. So there's no reason, I think, to get too jumpy at this point, just because we don't know what the final rule is going to look like. We don't know what's actually going to go into effect, if it ever will. But just be aware that this is out there. And as we're going to kind of talk about later, this is just a growing trend of disfavoring these types of restrictive covenants. So the rule, I will say, I know we talked a little bit about broad NDAs or non-solicitations. The rule does not prohibit narrowly tailored non-solicitation covenants, non-disclosures, those types of provisions. So as long as those are properly tailored, and again, you know, if you have any questions about that, or you know, let us look at your employment agreement and those kind of provisions and make sure that they are narrowly tailored. Because again, South Carolina already has laws that require these kind of provisions to be narrowly tailored. So we want to make sure that they are enforceable. Okay, next slide. There's also an act proposed in Congress that would basically accomplish the same thing, that it would also ban non-competes. And I won't go all into the kind of the nitty-gritty of the act. I think it's been introduced in the House and the Senate and hasn't made any kind of headway so far. But I really am including it just to kind of make you aware that, you know, we have this proposed agency rule. We do have you know, a bill that essentially would accomplish the same thing. And so, you know, this is kind of out there in the ether that, you know, everyone's looking at these types of rules and they're really disfavored by both courts and by our current administration as well. Okay, next slide. And just kind of reiterating, you know, this is a proposed law. We have no idea if it would actually make it through the House and Senate. But President Biden had said if it, you know, if it makes it to his desk, he will sign it. This is kind of a part of his agenda, his cabinet, this kind of going against these restrictive covenants in a sense. Okay. So I'm also going to talk about a couple of decisions we got from the NLRB last year. The NLRB had a very busy year. And so we're going to be talking about some changes, some things you need to be aware of with your handbooks, with your severance agreements that you're using. And then we're also going to talk about a new joint employer test. And so the NLRB issued this decision in 2023, the Stary cycle decision, where they basically said, so under the NLRA, employees have the right to discuss the terms and conditions of their employment. And their employer has to allow them to do that, and they can't retaliate against them from doing that. And their employer policies have to allow employees to do that. And so the NLRB has really come down hard on employer policies this year through this decision. And they've basically said, if you have employee handbook policies that could reasonably, well, I guess let me make sure I got the right standard here. The old standard was reasonable. If an employee could interpret that it would restrict them from exercising their rights under Section 7 of the NLRA, so that they could interpret it, not that they are interpreting it, then it's too broad and it's violating the NLRA. And the former standard before this decision was if a reasonable employee had that view. And so the new standard under this decision is if an employee who is economically dependent on the employer and is contemplating exercising their Section 7 rights, if they could interpret these policies as restricting them, then they violate the NLRA. So a much kind of lower burden for the employee to meet, if that makes sense. It's not using that reasonable employee standard anymore. So if you have an employee that's considering, discussing the terms and conditions of their employment, and they could interpret the policy as restricting them, then it's too broad. That's basically what the NLRB said. And so the effect of this is, we really have to look at, things like our confidentiality clauses, your social media policies, any kind of policy you have that governs like civility and what employees may be able to discuss with each other. We really need to be reviewing that language and making sure it is narrowly tailored in a way that is still in protecting the employer, but is also not so broad that it would violate this new decision. So yes, send us your handbooks. Let us take a look at that language. We've been doing a lot of revisions for people to make sure that it complies with this new guidance. And you should be updating your handbooks every year anyways. So, okay, next slide. So severance agreement, this is another decision that the NLRB came out with last year. And they effectively kind of said something similar. So still under Section 7 of the NLRA, but they said, if your confidentiality provisions and your non-disparagement provisions in your agreement are so broad that it would restrict the employee from discussing the terms and conditions of their employment, then they're not valid. That basically that those are not going to be enforceable against the employee. And so they, actually, let's go to the next slide because I put in a couple examples specific to this decision that came out. And so this is the language from for the confidentiality clause. And so it says, this is the language that the employer used. At all times hereafter, the employee agrees not to make statements to employers, employees, or to the general public, which could disparage or harm. I'm sorry, this is the non-disparagement. The image of the employer, its parents and affiliated entities, and their officers, directors, employees, agents, and representatives. And so this is the paragraph that was in the severance agreement that this employer had. And the issues that the NLRB took with this is they said that this is so broad that it would prohibit the employee from criticizing the employer or complaining or discussing the terms and conditions of their employment or filing a complaint or assisting the NLRB with a complaint. And so they just found this language too broad because it restricts them from discussing again with all employees or the general public. They also said that it prohibited any kind of statement that could disparage or harm. And they said, really, this language should be narrowed to only capture statements that are reckless or maliciously untrue. They also took issue with the fact that it protected more than just the employer. It applied to all the employer's affiliated entities and their officers and directors. And they also took issue that there was no temporal limitation. So it didn't apply for a limited period of time. And I will say in these decisions, this is a totality of circumstances kind of review that the NLRB does. So we don't necessarily know if maybe a couple of these were true and a couple weren't, whether that would have been enough for this paragraph basically to survive the NLRB scrutiny. But these are all the issues that they discussed that they felt this was overly broad. Okay, next slide. So this is the confidentiality clause that was in the agreement. It prohibited from the employer from discussing the severance agreement's terms with any third person, and then it had this carve out other than a spouse or a professional advisor for the purpose of obtaining legal or tax advice, or unless legally compelled to do so by a court or administrative agency of competent jurisdiction. And I will say these are pretty common clauses that we see. This isn't really unusual language in any kind of way. But you'll see that it restricted discussion of the severance agreement's terms. So it wasn't limited necessarily to the amount of severance. It was all terms of the agreement and to any third person. And so the issues that the NLRB took is they said this language reasonably tended to coerce the employee from filing a complaint or a charge. So it would discourage them from doing that or from assisting the NLR, that's supposed to be NLRB, with the complaint. And that it also precluded them from discussing the terms of the agreement with other coworkers or other coworkers that may also be receiving severance agreements and may be considering entering into that agreement. And so those are kind of the issues that they took with this. And again, there's a way to narrowly tailor these. And so if you have a template severance agreement that you've been using, let us take a look at that and just make sure, there are some changes we can make to make sure that we're complying with some of this guidance, but we're also still able to protect the company. Okay, next slide. Okay, new joint employer test. NLRB also announced this. Next slide. So this will go into effect February 26, 2024. And it rescinds a rule that we got during the Trump era, which was, kind of a more employer-friendly rule. And now the pendulum is really swinging to this being a more employee-friendly rule. And it basically says 2 or more employers will be held to be joint employers under the NLRA where they share or co-determine matters governing employees' essential terms and conditions of employment. And so those essential terms and conditions of employment, that is an important part of this rule. Okay, next slide. So if the company controls one of 7 factors, one of these 7 essential terms and conditions of employment under this new rule, regardless of whether they actually exercise that control. So that's kind of sounding similar to the independent contractor test we just got too. So regardless of whether they exercise that control, they will be found a joint employer under the rule. And so the board would use this same standard even when an entity is contracting with a third party, such as a staffing agency. It also comes up in the context of franchisor, franchisee kind of relationships. And so be aware of that. And so they also make this note that indirect control will also establish joint employer status. So again, maybe not control on its face, but if you have the right to be able to control it, it's going to trigger joint employer status. Okay, next slide. And so these are the 7 terms and conditions of employment. So if you have indirect control over one of these 7 factors, the NLRB is going to consider you a joint employer. So we're talking, and it's kind of the normal stuff that we always talk about: wages, benefits, compensation, scheduling, the assignment of duties, the supervision and performance of the duties, work rules and directions governing the manner and methods of how, you know, that person is working, the tenure of an employment, can you hire and fire, and then working conditions related to the safety and health of the employee. So if you have indirect control over one of these seven terms and conditions of employment, the NLRB would say that you are a joint employer. So very low bar for them to prove that, right? So this is a more employee-friendly rule that we are getting here. Okay, next slide. So what to do, recommendations for now. So make sure that you are reviewing your agreements with your staffing company or your leasing company, whoever you're getting your employees from, that third party, and make sure those agreements define who is responsible for which of these employment obligations. So who is responsible for those terms and conditions of employment that we just went through. And make sure you include insurance requirements and listing of employer as an additional insured. And then you want to make sure you have indemnification provisions in there where they are indemnifying you against any kind of claims of joint employer status. Okay, next slide. I know I went through that fast, but we have a lot to get to. Okay, Chris.
All right, extended OSHA reporting. Go ahead and hit the next slide, Brittany. So this became effective January 1, 2024, and the reporting requirements under it start February 1, so you've got till next week. What it did was expand electronic record keeping and electronic reporting obligations currently in place for some employers in certain industries. And the regulation defines the industries in appendices, appendices A and appendices B. And the type of reporting that this regulation is talking about, obviously, workplace illness and injury. So it's going to be your 300 log, your 301 incident reports, and your 300A annual summary. Next slide. The new requirement is that employers with 100 or more employees must electronically submit forms 300 and 301 if they are in industries listed on Appendix B. At the end of this section, I have the links to Appendix B and Appendix A, but there were a lot of industries, types of companies listed on Appendix B that I wouldn't have necessarily classified as high hazard. And the regulation, the explanations in the regulation said that they had added department stores, supercenters, and warehouses from Appendix A. So essentially, previously, the requirement was that employers with 250 or more had to submit certain forms, and that employers in certain industries from 20 to 249 employees had to submit. So what's happening now is it's been those that have 100 or more and fall into the Appendix B categories also have to submit. And this is in addition, obviously, to the annual 300A report. Next slide. So this is the coverage of what was there. The 20 to 249 employees, those employers that have that many employees, the industries that this applies to are going to be listed on Appendix A. And it's submitting the 300A annually. And then, as always, workplaces with 250 or more employees have to submit the 300A annual summary data. Next slide. So the point of this rule, this is not the slide about the point, but I do want to talk about that. This is the timeline, the nuts and bolts. The data must be submitted annually by March 2. And covered employers should be prepared to submit their 300A summaries starting February 1 through April 30. And those employers that have to submit the 300 and 301 incident reports for 2023 must do so by March 2. Next slide. So the point of this, the purpose behind this was that it would give OSHA more access to injury and illness data in hopes that OSHA could identify and address hazardous workplaces to reduce workplace illness and injuries. They are going to post collected establishment case-specific injury and illness information online, and this does not require them, when they're doing an OSHA investigation, one of the first things they ask is for the record keeping logs and the forms. This is going to eliminate that requirement for them for employers with 100 and more employees and some with 20 or more. Next slide. So here's the links we talked about. Here's a link to the rule and then a link to Appendix A and Appendix B. Thanks, Brittany. So be sure, please, and check out these and make sure that you are in compliance with the new requirements. Next slide. Brittany's trying to keep us on time. All right, so the EEOC proposed harassment guidance. This was proposed last year. Next slide. And it's interesting because the most recent guidance that employers have been using and people who help employers like me would be the EEOC's guidance from 1999 that outlines, all kinds of details about harassment, but then specifically what you need to do to perform an investigation. So this is going to be new guidance that comes to place and replaces all the prior guidances, which I've listed there. Public comment already ended and the issuance is expected in 2024. We will have a specific webinar for this purpose when it's issued. But today I just wanted to hit some of the highlights. Next slide. So there are provisions that address whether conduct is based on an individual's protected characteristic or not under Title VII. I would say that this is more specific than prior guidances and gives employers more guidance and in a way is more helpful in distinguishing for claimants and employers what is and is not based on protected status. I think that's important. Being consulted on this weekly and having to write, it feels like EEOC reports, EEOC position statements also weekly, and giving advice and counsel on it. Many employees think that they're being discriminated against on their protected status without even thinking about what protected status is. So this is going to be helpful. It also covers conduct that's directed at the claimant and not directed at the claimant. And this is going to obviously apply more to harassment. In our jurisdiction, we already have a case that says if it's harassment not directed towards the claimant may not rely on it with some exceptions. That's older case law. And so I would think that at this day and age, some of it might be. This harassment guidance that gives you specific instances of when it would. It addresses outside of work contact between employees, electronic, company or non-company. I always like to say the grocery store, social media, anywhere, and in virtual environments. And it also addresses sex-based discrimination in the context of reproductive decisions, including conception or abortions, gender identity, pronoun use, misgendering, presentation that doesn't align with a person's gender. This is already opposed by the EEOC's interpretation of Title VII and case law. But it is interesting about the sex-based discrimination as it might apply to conception or abortions and how that might impact employee benefits. Next slide. It also offered a new definition for harassment, removing the unwelcome conduct aspect of it, and instead using an objective and a subjective analysis. It offers harassment distinction with respect to how it's impacted an employee's change in terms and conditions of employment and defining them in two different ways. One would be there's an explicit change and it's on the basis of somebody's protected status, but the other would be that conduct that constructively changes the terms of conditions of employment, meaning that the harassment on the basis of a protected characteristic that is actionable in order for it to be actionable must change the terms by creating a hostile work environment that as a whole is so severe or pervasive so as to create an objectively and subjectively hostile work environment. So that's a meatier definition of when it's going to change terms and controls. And I think that typically this guidance is going to be more helpful for employers than past guidances. Next slide. I mentioned unwelcome conduct is being subsumed by instead that the conduct that is being referred to as harassment is both subjectively and objectively hostile. And it defines subjective and hostile work environments and gives examples. There is a section on proxy or alter ego liability, i.e., there's vicarious liability for an employer when they knew or should have known that another employee was harassing, particularly in supervisor liability. But in this situation, this would be where the harasser was also someone that was so significant to the organization, whether they be an owner or high level, CEO or decision maker, that it would be assumed vicarious liability. And then adds a section for systemic harassment. And obviously all the analysis that would go with systemic discrimination and harassment. Next slide. So here's the proposed guidance. There's a link to it. It's not a rule yet. And it won't be, I'm sorry, it won't ever be a rule. It'll be guidance. But remember this, that the EEOC always judges and investigates on the basis of its own guidance. And so it's important that employers follow it, and that advisors to employers consult it when they're advising on compliance. And additionally, there's always an investigation process, absolutely has to be followed. The EOC will tell you that you're entitled to a good faith exception, even if they think that you've rendered the wrong conclusion about whether or not the harassment or discrimination occurred. I haven't quite figured out where that helps us, but they do say that. What I will say, though, is that when they ask for information, they're looking for documented criteria that meets their definition of proper investigation. And that actually is important in court too. So this is something that we always recommend employers follow. Next slide. All right. Did y'all know it was an election year? I'm sure this is news to you. Next slide. So some things to remember. South Carolina and some other states make it a criminal offense for an employer to terminate an employee for expressing a political opinion. And I've dropped the actual statute here that says it's unlawful for a person to discharge a citizen from employment or occupation because of political opinions or the exercise of political rights and privileges. So what does that look like? Next slide. Case-by-case basis is how our courts interpret whether or not this statute has been violated, whether or not the employee was engaged in expressing a political opinion or an exercise of political rights. Violations carry with them a $100,000 fine and up to 2 years in prison. And then also provides a basis for civil liability that the employee brings against the employer for wrongful termination. So that is obviously going to be back wages and punitive damages and attorney's fees possibly. Next slide. Two cases, the most recent cases that we have interpreting this statute in the context of wrongful termination give us some guidance and some clarification. So the 2019 case, Owens versus Crabtree, specifically said it's okay that you can terminate an employee for using company equipment on company time to oppose a local building project that was valid. So this was valid. It's okay. Someone who's using our equipment and is doing this on our time and this isn't their job, it's okay that you can let them go. Vanderhorst is another one where the employee had a Confederate flag sticker on his toolbox and he was discharged. And the District of South Carolina, the federal court interpreting South Carolina statute, concluded this was not a political opinion or exercise of a political opinion or right or privilege, just having the sticker on the toolbox. So you can see our state is, in my opinion, issuing employer-friendly decisions, which makes sense, particularly the Owens Crabtree. That's an easy call. But you could make the argument that a sticker on a toolbox could be considered political expression or speech. I think they interpreted political very seriously, though, or very specifically, very narrowly, and that posting a Confederate flag was against company policy, which you could see why employers would want to have that rule. Next slide. So here's some recommendations. Have some respectful workplace policies or code of conduct. Enforce them. You can discipline for conduct that disrupts the workplace or business operations. So you have an employee who is ranting and raving about their political expressions and going on, and it's either making it difficult for other people to work around this person, or it's interfering with people getting their job because it's all going on during the workday. You can absolutely discipline and terminate for conduct like that. Considering consider updating your personal use policies. If you permit minimal use, how will you distinguish if it's on lunchtime and it was a political expression of political opinion, or engaging in exercising of political rights and it's lunchtime, and I'm permitted to use the company systems for minimal use. That takes it outside of the Owens for holding. And there might be an argument there that, depending on what court it is, there might be an argument there that termination on the basis of that, or discipline, but termination is the one that carries damages, would run afoul of this statute. So why not just have a no personal use policy? I tend to think that's better anyway. Update the conduct policies to include conduct that disrupts the workplace or business operations. That is something that we have been adding into our conduct policies, including gossip or other negative conduct into the conduct policies. So those are the things we would recommend to help deal with what will be strife over the upcoming election, because of how polarized our society is now. Next slide. All right, that's Katie.
Yeah.
And we have 4 minutes left. Katie, and
I'm fast. Okay, so these are employment law trends, maybe not taking place here in South Carolina, but we're seeing it nationally that we just want to highlight. Paid leave is a big issue in a lot of states. Roughly 20 states and 30 local jurisdictions have implemented paid sick leave laws. And again, you see this year, these states that are listed have updated their paid leave laws. And in 2022, South Carolina, actually, the governor signed a law that allowed for paid parental leave for state employees. So we've seen it in South Carolina for state employees, but more paid leave is a national trend that we're seeing in other states. Okay, next slide. Marijuana, always just a big issue. I saw this statistic down here. I think Brookings Institute or someone had it, and I failed to put that on the slide, but 54% of Americans now live in a state with some form of legal cannabis. I found that really interesting. And so again, this is just something we're continuing to see other states, local jurisdictions pass laws or ordinances that allow for either medical use or recreational use. And of course, we have a proposed law here in South Carolina that is for medical marijuana, has not been approved in South Carolina. Again, is banned on the federal level still as well, but it's a trend that's been coming for the past decade, really. Okay, next slide. Minimum wage, we know the federal minimum wage has not increased in a long time, but other states, if you have employees in other states, these states, January 1 went into effect new minimum wages. Again, we don't see that here in South Carolina. South Carolina hasn't raised its minimum wage, but if you have employees other places, it's something to take a look at and be aware of. Next slide. And again, just circling back to non-competes, we're also seeing states take action on restricting non-competes. And so 5 states have completely banned non-competes. And then more than 20 states have other laws that limit these restrictive covenants in some kind of way. So again, this is just a national trend that we're seeing across the board. I think that's it. Next slide. Oh, yeah, Chris, I'll let you hit that.
All right, real quickly, I'll hit a question that we just got. Well, it's 1 minute till, so I'll remind everybody. Our next seminar is February 22. Garrett Steck's going to come talk about immigration, and we'll probably jump in and talk about something else because he says he only needs about 30 minutes. March 28, we have Ron Scott, who is a partner in our office. And he, in his former role, had to deal with the Employee Polygraph Protection Act. And I had to work on a case with him this year on that. And he so impressed me. And it's actually very interesting. And so I asked him to speak. So he'll be speaking for us on March 28. We're looking at the topics you suggested last year and populating those in the remainder of our webinars, which we hold every month on the 4th Thursday from 12 to 1, except for July. And then next slide, we have a quick blog links to some of the things that we talked about today so that you can look more in depth for some of the topics if you need more in depth right now, based upon what we said, because we did just have to hit the highlights. So here's the question, and those of you, thank you for coming. Those of you who need to jump off, thank you for coming, and we'll see you next month. Let us know if we can do anything for you. The question is, what if a colleague was late due to voting? The late arrival took the colleague to termination level. Would that be considered terminating based on public opinion? No. If there is not a policy that requires or permits employees to be late on voting day, or if that particular employee did not ask for more time, or said they were going to be late, and there is a policy about when an employee should report, and this is someone who doesn't have accommodations exceptions to timely reporting, and it's it's required in the job, then an employer is allowed to discipline as they see fit. So terminating is an interesting outcome, and presumably there would have been other things afoot. Typically there are, but even if not, an employer has a right to do this as long as it doesn't run afoul of our laws, our state and federal laws. All right, so yes, the slides will be shared. Thank you, Katie. And we'll see you soon. Thank you, everybody. Have a good afternoon.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.